Mr. Needler, I think I'd just like to get a finer point on your position. When we talk about Twitter or YouTube or Facebook, it's because of the algorithms and how broadly these businesses are. It's complicated. But I'd like to simplify it just a bit and see where you come out. You recall PageNet, don't you? When pagers were ubiquitous?
Yes. I don't recall PageNet, but
okay, well,
I'm
let's
not
just,
an expert in.
Well, yeah, well, just pagers were ubiquitous at one point, right? And let's assume that, as with certain criminal elements who used pagers back then, you had terrorists who had an affinity for these. And that the PageNet, let's assume there was a company, PageNet, understood that they used their services, as did doctors, as did other people, business people. Would that constitute aiding and abetting if they did nothing and permitted them to use it and engage in terrorist activity?
By application of the Halberstam standards,
yes,
that may be unclear, but I think it would probably not be substantial assistance or knowing substantial assistance.
Okay, so if you would just parse that for me.
Right.
You know they're using it, and you know it's probably central to what they're doing. So where does it fail, the Halberstam test?
I think there's one distinction between this and between your hypo in this case, which is the distance between the aid and the commission of the act. In your example, it's much more proximate, I think, if I understand the hypothetical. Using the pager will be alerting somebody to the immediate commission of the crime. That's not what we have here. Here we have something that is much more remote, the use of an automatic service that the claim is that enhances ISIS, which in turn may be in combination with a number of other factors.
Well, that's why I went to pagers, because I wanted it to be closer.
Right.
And I wanted to put a finer point on it because, you know, of course, a billion people or hundreds of millions of people are using these services, and so you get lost in that. I understand you say that's too amorphous or it's too attenuated. But if you tighten it somewhat and use pagers, it would seem that you would be able to answer that with more clarity.
Yes, but I think, frankly, it's somewhat in between. And the hypothetical that you're describing, I think if you look at the Halberstam factors, which is an important part of the Halberstam test in deciding what's substantial assistance. And by the way, that's not just a factual question. In Halberstam itself, the court first affirmed the district court's factual findings and then applied its legal test. And by application of the legal test, which is those 6 factors, the court was able to find liability. In a number of the other cases, they've been dismissed because the allegations don't make out a legal standard. It's not so much a question of fact. But in your hypothetical, the 3 most important factors we think in this case, I think, bear on your question. And one of those is, Halberstam puts it in terms of, was the person present at the commission of the offense? I think that's maybe a proxy or a window into the question of how proximate was the person, the defendant's action to the ultimate act. And in Halberstam, obviously, the court said she was integrally related. Here we think it's not proximate either in the legal proximate cause sense or in the factual, the way the internet works sense. In your example, it's more proximate, both, I think, in a factual and maybe in a legal sense, that the use of the pager would have, depending on, there may be other facts, and the level of knowledge would be an important element of that. And another very important factor, I think, in Halberstam that would be relevant in the case that you're describing, but I think is very relevant here, is what is the state of mind of the person, of the defendant in the case. And here the Court of Appeals said it's undisputed that Twitter and the other defendants here did not have an intent to further ISIS activities or the particular terrorist act here.